All right. Hello and welcome everybody to tonight's session. I apologize as usual. There's a little background noise here with some family members being a little unhappy, but of course we've got a great panel for you tonight. This has been 4 years in the making. These regulations came out a while ago. We're finally gonna be able to talk to them, folks. So these regulations about Emergency Rule 64 ER 21-16. Essentially what it is the people on the panel actually know what it is. The rest of us are going to find out tonight. So I'd love for everybody to meet their panelists. We have Erik, the board chair of Minorities for Medical Marijuana. We have Coyle, a corporate partner at Fox Rothschild. Vijay Choksi, the Cannabis Counsel for Fox Rothschild, and Vijay is on every single panel from now until 2024. And then DJ Howard, the State Director of Florida for Minorities for Medical Marijuana. Of course, folks, we have a great program for you tonight, but we have some other great events coming up. On December 7th is our members only holiday party. So if you're thinking about joining and you haven't joined yet, join before December 7th and you'll get access to our holiday party. It is always a good time. On January 20th, we have Meet the 2021 Cannabis Lab Leadership, where you'll get to meet all the leaders of this great organization. The following week will be the year ahead in cannabis. And then on February 4th and 5th, we will be down in Miami for the annual CA Lab conference. And that is not an event that you want to miss. If you want to get an overview of the overall national cannabis landscape, that is certainly the event for you. So folks, please stay tuned. Enjoy today's program. I believe we'll be taking questions at the end. And with that being said, I will turn this over to our panelists.
Awesome. Thanks, Todd. Appreciate it. Welcome, guys. Today, we're going to be talking about everything about Black farmers and the In-Ray Pigford-Glickman license. So essentially, just a few housekeeping things, as Todd mentioned. If you do have questions, go ahead and type it on into the chat. At the end of this, we're going to go ahead and try to take as many questions as possible. During our conversation, if you have anything, again, just type it in. And just a few housekeeping things I got to get into here. Whatever Sean or myself say, we're not providing any legal advice tonight, and any comments or remarks are not a representation or view of Fox Rothschild. So, all right, let's go ahead and get set and started. I think it'll be a little helpful to kind of just go over of what a little background here, what Pigford is. But essentially, like Todd said, this rule was 4 years in the making. 381-986, which is the Florida statute, necessitates that one medical marijuana treatment center license, get awarded to a class member of Pigford v. Glickman or In-Ray Black farmers. And what those two cases are class action lawsuits. It was primarily issued due to historical discrimination actions against Black farmers from the United States Department of Agriculture. And essentially, there was USDA racial discrimination against Black farmers between 1981 and 1996. And it was primarily due because the USDA allocation of farm loans and assistance was not necessarily available to Black farmers as it was available to their white counterparts. And the USDA took a long look at itself, and it actually admitted that it was discriminatory through its own internal investigations. So the discrimination has been well documented, and we see that impact today. Essentially, farms run by African Americans make up less than 2% of all the farms throughout the entire country today. And that's largely part and due to the racial violence and unfair lending practices of the USDA. But essentially, that's just a little background and overview. But let's go ahead and kind of get it started. Like I said, the rule stipulates only one Black farmer license. And I know Erik and DJ, you guys with Minorities for Medical Marijuana, you guys kind of laid the groundwork on Florida's medical marijuana program in 2016. Can you kind of just share with us like what you guys did, how you guys get that that racial equity portion addressed back in the day when this program first started?
Yeah, back in 2016, when we passed our constitutional amendment, from the voters, that was the same year that Minorities for Medical Marijuana was founded. And so we were partnered with then United for Care to get that passed here in the state. And then we participated in the legislative session in 2017. During that session, we were able to walk away with a couple of things that we worked on. One of them was the diversity language, which is a part of the Florida law, the statute, so requiring all of the license holders to have a diversity plan. We also was able to get Florida A&M involved with $10 for every medical marijuana card here in the state of Florida to be able to do outreach and research, and then also for them to be able to participate with a hemp pilot program. So those were the three things that we primarily worked on. We were involved in some discussions regarding the Pickford, class at the time, or the conversation at the time. But even then, we were very vocal about this needing to be expanded beyond just one license, and that there were several Black farmers throughout the state who wanted to participate, and that limiting this to just one Black farmer was in and of itself problematic, and something that we felt we could have done differently then. But at any rate, we applauded the state because we felt at the time, Florida was was leading the way in the country. No one else in the country was really having this discussion about how an industry that was born out of and born on the backs of the war on drugs, how that industry also has an obligation to repair the harm that was done because of the war on drugs. And so Florida was kind of leading the way in that. Unfortunately, we find ourselves now in 2021, and we're still, haven't even issued that one license, and we are light years behind the curve when it comes to where this industry is as it pertains to social equity and social justice.
Yeah, like you said, it's been a while. We still don't have that license awarded. It's been 4 years. And I know the Department of Health, Office of Medical Marijuana, was kind of holding off on issuing this whole rule, essentially, and even the application and the evaluator instructions until there was a resolve in this famous Flora-grown case, which was filed by the Tampa-based Flora-grown company, which essentially challenged the vertical integration provision that is contained in 381-986. And I know, Sean, you, to a certain extent, your former firm, Ackerman, was highly involved in that. Can you kind of give a little background on how we are today and where we're coming from?
Well, after repeatedly beating the state at every level of court, they ended up in front of the Florida Supreme Court at a hearing. They ordered a secondary hearing once DeSantis's new court nominees were put onto the court, and the state got their one win. And despite basically going 1-7, the state came out victorious. And vertical integration, for now is, here to stay, for better or for worse.
Yeah, for sure. Essentially, here we are now, right? Where we have these application instructions, we have this new emergency rule that essentially wasn't necessarily workshopped, just kind of checking the box on the statutory requirement. And now we're to the point where we're on a little bit of a holding pattern, waiting for the department to issue the window where applicants can go ahead and start to apply. I know that we all took a look at the application itself as well as the evaluator instructions, but before we kind of dive into that and sink our teeth into that, I kind of just wanted to get a pulse on DJ and Erik. Feel free to jump in, being that you guys are very involved on the political side of things. Can you shed some background as to how this emergency rule kind of just popped up randomly on October right before Halloween?
Yeah, it was kind of interesting how it the timing of it, right, of when it came about. Right before the holiday season, things are really getting busy. And when it was released, it really was given without any explanation, any warning, really. And the rules were kind of just thrown down, like you said, not workshop at all. So it was definitely very interesting with the timing of it all, and understanding that the window of opportunity to submit your application is not very transparent. Obviously, it states the 5-day window, but when that is up to be guessed by the group and everybody else involved, which makes it very tough for the applicants, especially this time of the year, being very sensitive to like the holiday season, everything going on. It's really like a waiting game. And that's the part that's, like I said, very challenging. We've seen in other places where people have 3 weeks, 4 weeks, even longer notice at even minimum. And we're kind of just waiting to see what happens and trying to get as much together as possible when the emergency rule was just, announced within the last month or so, maybe a little over a month now.
Yeah.
It to be honest, is highly frustrating because, for years we've just been sitting where it was almost like we couldn't move, we couldn't do anything. The Office of Marijuana Use was willing to move forward. The governor's office was unwilling to move forward and settle with this Pickford license. So we did nothing. And then out of the blue, we get this rule. And how I found out was literally, I woke up to a text message from a reporter asking for comment. That shows you just how much notice we were given, as an organization that has been extremely involved on this topic throughout the years. We would have loved to have been consulted on this. We would have loved an opportunity to weigh in on, with the health department on this particular rule. But that wasn't given. And so you're right, we're here. The rule is out. It's a lot in it to, that leaves us very frustrated. Again, no transparency, no explanation behind things. And then we're back to this holding pattern where it's like, it could come into, Christmas night, applications open up and now folks have to rush. And when we talk about the Pickford class in particular, having been a class of farmers that has already experienced a tremendous amount of discrimination at the hands of government entities, I can't see how we would be going through, this route with this particular license.
Yeah, and I'd add what's happening now, or what I've been seeing on the transactional side, is there's been something of a land rush for MSOs and other entities that are in other states, or would-be operators in Florida that are not part of the Pickford class at all, have been partnering up or essentially trying to force their way in and provide support to the application for basically driving the bus. So if the intention was to deliver this benefit to, the class, I think what's happening now is, not what was intended. And at the same time, these claimants by their nature are farmers, and the verticality within Florida will force them. Cultivation is one thing that's arguably within their wheelhouse, but force them to also become processors and retailers, which aren't, necessarily a natural part of their specialty. I'd say they are not in large part. And so from an operational perspective, then they actually need to partner up. So, again, the economic benefit at the end of the day being delivered to one lucky winner isn't even, you know, the full boat, and it's a little bit of a cursed gift in a way because of verticality and because of the short window and because they need to get these applications in and bring people on to fulfill, you know, two legs of the supply chain that wouldn't necessarily be their specialty, and also have this capital to hold open LOIs on properties. For example, hold open LOIs on stores. You have putative applicants now running around, basically looking for risk capital to keep these options open and keep these things open so they can put forth the best application. And it's money they will never get back in this circumstance.
I mean, you're really touching on something here that I think is not really understood by most people. You know, most people who are going to be entering into this Pickford application pool have never even driven out to a farm that's owned by a Pickford farmer. I've driven out to several here in Florida, and I can tell you what we are asking them as a state to do is putting them in a position in which they won't own the very license that was set aside for them. We don't have any minority licenses in the state right now. Out of the 22 licenses, that is majority owned by a minority. And we won't after this Pickford license. And again, that was the intent of the law. And so, you know, I foresee that we're going to have a whole lot of litigation, you know, as a result of this, which is going to hold up things even further. And unfortunately, I'm very concerned that we won't still, at the end of this process, we still won't have a Black-owned license here in the state of Florida.
Yeah, and it's really tough. Oh, sorry, Vijay. I was going to quickly say that's really tough. Eric brings up a point that I was actually thinking about when Sean was speaking, of just even how, and we're talking about the Pickford license issuance, but even just how we have to get so creative if we really want to push inclusion in the space and being able to get Black farmers who have a specialty and have the know-how, or even people who are suppliers or have different brands into the space and partnered with these different companies outside of the Pickford, just because, as we're outlining and we're going to continue to get into, it's really tough to even retain the ownership aspect in it, and to be able to get into the pool of applicants is even very, very difficult for most people to be able to do without the generational wealth that, you know, would be expected and all the capital that would be necessary. It's almost at a point where if we really want to see the inclusion, we're going to have to get creative and think of other ways to get these companies to want to partner with Black and brown suppliers and brands to be able to have that stake into the industry.
I think we all touched on this. Go for it, Sean.
Yeah, and you're actually seeing this throughout the country writ large in terms of social equity programs that are failing or underfunded or just can't deliver on even some of the basic tenets of their intention because of faulty design and not really thinking through the process. And so you're seeing that on a national scale, and you're seeing it, you know, on a smaller scale now in Florida with just the type of things we're talking about. How do we actually keep the ownership with the people who are intended to receive the ownership?
And it's here, and we're at this like point, and everyone kind of touched on it. We're at this point because of that historical discrimination, and you know, essentially Black farmers have lost 80% of their land due to these discriminatory practices because they had to take on debt. Essentially, you need in modern farming, what these farmers have to do, they had to take on debt to even operate. You need debt to grow your crops. You need to, in order to collect a harvest, to pay for fertilizer, to pay for labor. And they got their land repossessed. And now we're here in Florida where they need capital partners because VI is expensive. And they might get their license taken away at the end of it. So the very reason of this law was discriminatory practices and having, their property taken away. And now we may end up with that same result where we were trying to mitigate against or protect or right or wrong.
Vijay, we may not even get that far. I mean, the application may not even have where the ownership at the application stage may not be in the hands of who it was intended, because in order to raise the capital to even submit the application, Sean touched on it with the LOIs and so on that you have to put out, different, partnerships that you have to get involved with. Very few companies are going to come to the table with all the money and give up 51%. Right now, nothing in the statute, correct me if I'm wrong, nothing requires them to be 51% owner. So, we're going to have Pickford applications in which at the application stage, the Pickford won't be the majority owner. They'll just be another, pawn that is a part of the application, and won't have but a few percentage points. And again, that's not what was intended. I understand when raising capital, perhaps you have to be flexible, but I think even in the application phase, at the very minimum, we should require that in the application they retain ownership. What they do afterwards to raise capital to stand up the operation, is a different thing. And that in and of itself can create a generational wealth opportunity for a Black farmer. So, I mean, again, it's like Sean said, the devil is always in the details. We've seen this countless times across the country where and we can even call this a social equity program here in Florida. This was at the time, our attempt to try to, right a historical wrong. But, again, even at that time, we clearly weren't thinking all the way through this. And now when we have the opportunity, it is very disappointing that the health department hasn't learned lessons that we have clearly seen across the country, because again, there is a right way and a wrong way to do this.
And it also speaks to the larger issue of lack of credible cannabis banking and lending. I mean, oftentimes these farmers do have land, so they have collateral, but you don't necessarily have a bank that will willingly lend to a cannabis project at anything in the single digits. Let's say, so you're paying above market rates if you could even find it. Most often you won't be able to find it, which is where, these MSOs and other companies sitting on dry powder, sitting on cash, become your de facto bank. And, they're not in it for the interest. They're in it for the equity. And, I think with that lack of banking options, it just, further compounds the problem and causes this problem. That affects everyone across the cannabis industry.
Yeah, and we touched on financials, and when we actually look at the scoring apparatus for this application, it's a comparative qualitative analysis approach that OMMU has adopted here. And the scores, there's 9 sections where you can actually get possible points. And these 9 sections comprise about 30 subsections, and each section is about 200 raw points for a total of 1,800 raw points. But each section is not equal. Things are weighted differently. So, one of the most important sections, of course, is going to be your cultivating, your processing, dispensing, and then security and accountability. But another big portion of that is financials. And if we look at all the sections as a whole of the application, the most score heavy, weighted the most out of anything in this entire application is your certified financial statements. That's where you're going to get the most points out of any subsection in this entire application. And you got to show that history of actually having the funds to operate a VI system, which we all know is not cheap. It has to be, generally accepted accounting principles. It has to be generally accepted auditing standards that you have to adhere to. So it's essentially a big hurdle to pass. And, I don't necessarily know if all the blame, or the majority of the blame could even be put forth on OMU. OMU is just an administrative agency putting forth their statutory requirement of the legislature. So a lot of this blame really has to go towards the legislature here in terms of their idea of creating social equity, or their intent of trying to award or diversify this license. DJ, I see you're nodding your head.
Yeah, you said something, Vijay, there, that word intent, right? Like, what is the true intent behind it, and how much effort is really put into it when you think about how it's weighted. And somebody said earlier, the devil's in the details. When you start to go and comb through it, you realize different things are weighted, different sections are weighted in different ways, and the sections that are weighted the heaviest really are the sections that are the biggest challenge for a lot of folks. And it's almost, it seems, and it could be frustration. It seems like it's almost set up in a way to fail and not be able to have as many people within the pool as there are actually opportunity in the state as far as Black farmers go. And that's really, Erik mentioned earlier about the frustration behind it. It's really tough because it makes you question and wonder about the intent when you consider that people, it wasn't really workshop. People weren't brought in to consult and be able to talk through some of these things. So, I mean, we did wait, 4 years. You would think that within that time, we could have gotten some true work done. But that intent, when you said that word intent, it really made me think, because like combing through the application process is going to be very difficult. I don't know when we're going to get into questions. Somebody asked about the pool size of how many people are actually qualified. And, I mentioned earlier about getting more creative and being able to find other ways to be inclusive that is a workaround the legislation. Figuring out ways that we can do that is really going to be important moving forward. Obviously, fixing this, if we can fix this, that's one thing. But then just looking into the future, what we can do to really be inclusive intentionally, and figuring out ways to make that happen that's more feasible and that actually benefits the people who it should.
I think what DJ is talking about is in part, there's a lot of people that have to be held accountable. The operators in the space have to be held accountable, and that goes beyond anything that's in the legislation, or in statute, in administrative rules. I place a lot of blame on the legislator. Here we are, 4 years later, and nothing has been done in this particular, industry. We could have moved this Black farmer situation from underneath, the current bill that was being challenged by Florida Grown in order to award that. The governor could have settled that case a long time ago if they chose to do so. So I place a lot of blame in a lot of different areas. I think there's usually a rush to wait when it comes to set asides like this, or anything dealing with social equity. We're told time and time again, we got to wait. But I think a lot of people dropped the ball. The legislator, our governor's office, and the health department, as well as our current operators. We need to be doing more from a standpoint of connecting with supplier diversity, connecting with all of those things. So that DJ mentioned. So there's a lot of blame to go around, and there's a lot of work to be done. And our organization is going to continue to be a part of trying to move the needle on that. But right now we're dealing with a situation where we have this application that could open up at any moment. The situation is what it is. There are a number of Black farmers here. I'll tell you, I've met a number of Pickford litigants myself personally. But there's a lot of challenges that we just don't understand. When you talk about being able to produce documentation and show that you were a part of the Pickford classification, well, that presupposes that you guys during that time had good record keeping, which we know isn't the case. Especially as farmland has been lost and passed down to generations, and those documents get lost. I can't tell you how many farmers I've met who can tell you that their parents received the payout. They know that their parents were a part of it, but they have no documentation to be able to prove that. So by default, they're out. So there are Pickford litigants who want to get in. There are some who are going to come to the table with farmland and nothing else, and they're going to need capital. They're going to need partners for every other component. And then there are some who are going to come to the table and going to have everything that they need. And it is my hope that those are the ones who rise to the top and are able to get this license, so that we are able to realize the true intent of it. But you have a lot of creativity going on, like finding Pickfords from outside of the state of Florida, which again, that's a Black farmer, and I am open to that. But the intent was for a Florida farmer, and I know Pickford farmers here in Florida want to get in. I know Black farmers who weren't a part of Pickford right here in Florida who want to get in. And it's such a difficult thing to be able to really navigate through it, to have a real shot.
Yeah, you need to be 5 years of operating an entity to apply as well. So, good luck trying to find an applicant who checks all those boxes. And essentially, today was the day where they did release that new emergency rule, and they did open up the window. So there was Today was in the release of emergency rule 64 I believe it was 19. And essentially we have 109 days. So applicants have 109 days starting from today in which they can go ahead and submit an application pursuant to the instructions and the application scoring method. So, the finish line has been drawn, but I kind of wonder, because there's so many flaws with this rule, do we envision any sort of challenges happening after the issuance of a license, or even prior to?
So much.
This is Florida.
So,
Absolutely.
I personally think that's why this application process isn't running in tandem with the other 18 or so licenses that the state has to issue for the statute and held off on during the pendency of forward round, is because I think they're going to use some of those licenses as settlement tools with applicants that don't win and feel wronged by not winning. And, frankly, they're not wrong to award only one of these when you have, a fairly large class of litigants. Is you're actually, statistically, you're likely to have, a handful of applicants that are going to be very, very close to one another and almost indistinguishable in terms of what they're offering, what their application looks like, and what their qualifications are. And they'd be silly not to sue. And Florida already set a poor example with this, with the one-pointers. How did they settle with the one-pointers? They gave them all licenses. What happened? 7 of 8 of those one-pointers are already sold their licenses, cashed out. So, that's what it's become, because they'll use these licenses as settlement tools.
But I hope that happens. That has always been my hope, that those who didn't win would be able to sue and get a license like others have done in the state. But to be honest, the way that the emergency rule was written, it says that those, if you don't win in this particular Pickford cycle, you wouldn't be considered in other cycles. You wouldn't be grandfathered in those others, which is what we've done with other licenses. So that was explicit in the actual rule, which is one of the things I do believe will be challenged. In court. I anticipate we will see a lot of litigation from this. I hope, it's my hope that doesn't further delay the award of the license. But I anticipate there'll be a lot of litigation for a lot of different reasons. And you'll have Black farmers who weren't part of Pickford suing. You'll have those. I don't know. We're going to see quite a bit, but I hope that in the end, something is done that the state recognizes that one license. Again, if we award another 18 licenses, they're going to take us over 40 licenses. And if we're satisfied with just one license, that's a really sad state of affairs for our state.
Erik, what are you seeing in terms, Erik or DJ, in terms of meeting with, potential applicants, the Pickford class, Black farmers? What are you seeing in terms of the average age range? Because the perception that I have, and I think a lot of people have, are these are people that are very, very old, relative to where other applicants are and businesses are and principals are, and what effect that may have, because my prediction is this license, it gets turned around.
That's a misnomer. There are well and able-bodied Pickford litigants out there who are running their farms, who have been running their farms. Are there some who are older? Absolutely. Because again, the whole Pickford, litigation, from a historical standpoint, there was about a period of like 20 years where there were smaller litigations at state levels, against the USDA that were thrown out, were never heard. Though all of those culminated and it brought together the class action of the Pickford lawsuit. But there was, lawsuits and litigation for decades, prior to, to that. There's certainly some older Pickford out there. There are others who have inherited their land from a Pickford. They're fourth, fifth generation farmer, and their parents were, a part of the Pickford litigation. Again, what does the statute say about those individuals? Are they, qualified in this regard? If they've been farming on the land consecutively for, 70 years, 80 years, 100 years, and their father and their grandfather was a Pickford, would they be, allowed to apply? We don't know. The statute isn't there. So again, that's why I think we are going to see quite a bit of litigation, because there's a lot of people who want to get in, and there's a lot of uncertainty and a lack of clarity when it comes to just what we intended for this license to be.
Yeah, I was actually going to say, not a question of if there's going to be a challenge, how many challenges, like what is going to be challenged is really more so going to be the thing. And to Erik's point earlier, that's where my concern plays into extending this out even further for a lot of people who've been already waiting a really long time. If that, has an effect on it, then obviously, we want as many Black farmers in the state to be able to build generational wealth. But, it's taken so long, we really want to at least be able to get the one done and then see how we can get creative and grow from there, which we've talked about. And I know Minorities for Medical Marijuana, we have a lot of programs where we are trying to connect more people in the space with different MSOs, different companies who are already in the state and operating, so that they have that opportunity through programs like our InProcure program, which really tries to connect Black suppliers with different companies in the state. That's going to be where, like I said, we can kind of get creative and figure out some other ways to have the same intent and have the same goal in mind, but also look at other ways to go about it. Because like I said, there's so much within the Pickford that's going to get challenged, and we don't know how that's going to go. And for a lot of folks, the waiting thing is really at a point where it's truly detrimental. So people have to find other ways to make sure that they can get into the industry.
Yeah, I totally agree, DJ. You nailed it on the head. It's not a matter of if they get challenged, it's how many and when. And who's going to challenge it, right? I mean, it could be Native Americans, it could be women, it could be others. The list goes on. OMMU knows that they're going to get challenged. They sought about $2.15 million on their budget proposal just for litigation. Essentially, they asked for 13, and 2.15 is just for litigation. So they know it's, and they estimate 2 million worth. A little over
for it, yeah.
So we'll see. I kind of wanted to get into questions because we got about like 20 minutes left. This question comes from Joseph Stadlin, and Joseph asks, what are your best guesses as to time frame to actually award? i.e. how long to score, how long to handle litigation challenges, and how long to finally issue a license. Well, essentially, we don't know how long the litigation is going to actually take, but we do know a few things just based on past precedent. Sean did mention the one-pointers on when they sued. And we don't necessarily know at what provision they're going to sue. I mean, we saw what happened with Floor This rule was, this rule was made, but it's 4 years into the making where we're actually 109 days away. So it depends on what gets challenged. And then it also depends, if we look at prior precedent, if they are going to enter into some type of expedited settlement, which I believe, the department has some type of provision that involves like an expedited procedure for challenges, meaning that, at least in their eyes, the licenses could potentially be awarded within months, pursuant to their thoughts. But you never know. Lawyers are a creative bunch. So, we'll see how long it necessarily takes. Any insight from you guys?
Yeah, I would say in my mind, I don't see anything before summertime next year. I think the process is going to take a little bit longer. I know that's not, that may be sobering for those who have been waiting for such a long time, but this process hasn't been very quick here in Florida, so I don't anticipate it'll be quick this time either.
Yeah, like we said in the emergency rule today, right? They got until March 21st to the 25th. So hypothetically, it closes on March 25th, that 5-day window at 5 p.m. Then at that point, OMU has about 75 days to complete their evaluation and their scoring. So, let's do the quick math there.
Yeah, late summer.
Yeah.
At the earliest, right?
If all goes perfect.
Which is interesting because, they're targeting releasing the broader applications for the other 18 or so licenses in July of 22. So, it's the interplay between the timing of those two will be interesting to see, because again, I think if there is litigation around this, the state's just going to sit on those other licenses until that gets resolved.
Yeah, and even on top of the other 19, they got to issue more and more and more, because there is a step lock provision baked into 381-986. For every 100,000 patients, they have to issue 4 more licenses. Right now, I think we're hovering around 650,000 patients, give or take 10,000. So, imagine how many patients we would have by July 2022 or July 2023, especially considering if certain provisions get passed in the legislature, like telemedicine or reciprocity, that could also increase the patient count, which it could explode. And we saw that during the pandemic with the telemedicine provisions that were set forth via emergency action. Patient populations boomed during the pandemic because the ease of, getting in front of your phone or your computer and seeing a doctor via telemedicine. So there could be a lot more. We'll see. But taking this application under focus, we have one. And this is not like other states, like for New Jersey, for example, where it's administered on a rolling basis. This is going to be a very competitive process, highly competitive, just for this one slot, probably more. But, I'm thinking at least 100, maybe 150, 200. What are your guys' thought in terms of, how many applicants will see this go around submit in March?
Erik, I think you're on mute.
That 100 is a big number. That would absolutely mean that we have tons of applicants who are not Florida Pickford, which would be a little bit disheartening for me. Again, I would love to see a Florida Pickford get it. But in terms of Florida Pickfords, I think, the number would be relatively low. I don't see more than, 10 to 15, pulling together applications. But I definitely think there'll be others from outside the state. But again, it's my hope that it'll be awarded to someone who's a Florida, applicant.
Yeah, I think especially now understanding the time frame till March, having a few months, the key I think game changer there is going to be how many of those outside of the state applicants we get. That's going to drive the number up.
You know what we're also missing though, the real kind of elephant in the room is what will the legislator do this session before we get. I mean, now that we have dates,
there, yeah.
we clearly. I almost feel like this may be a nod from the health department to see what the legislator will do to help clarify this. Obviously we're going to be working. There's some things that we'd love to see clarified and changed in the language, and we'll be pushing towards that. And I assume there will be other groups doing the same thing, knowing that they have this time, during the legislature. But again, that in and of itself could, it could force the health department to have to go back to the table on rulemaking. And that could, even blow up this March, date that we're seeing now. So I think it's still too early to really, say how this is all going to play out, because there's a lot of voices that have yet to be, to weigh in on this. So we'll see.
Yeah, I think that's a great point in the sense that, late March is the same exact time when legislative session next year ends. So it's not too much of a coincidence of why those two dates sort of coincide there.
Right.
And, we'll see. It might even be a good strategy for members who don't necessarily qualify, or an interesting strategy of members who don't necessarily qualify for Pickford, of just submitting an application and assuming thereafter on a basis or whatnot. Not sure, I don't know. I don't have a crystal ball. We'll see what happens. But I'm sure everyone will have their popcorn ready to kind of figure it out.
This is Florida. There will be fireworks.
Yes, indeed. So, with that, gentlemen, I guess I will just kind of go on a round table and just give some closing thoughts, unless we have any questions that come up in the interim. So, essentially, I'll kind of kick it off with my closing thought. I definitely think that, the situation at hand, the intent was not met. The intent was not met by the legislature, and hence we're given only, a situation where it's going to be very difficult for those who qualify properly under the statute to actually have and own that license. And we're stuck in the sense that, whether better or worse, that they're going to have to partner with other operators to put forth a competitive process here. And, this is going to be a very competitive process in the sense that winner takes all. According to the instructions, whoever has the most points wins, just like any other game. And this is going to be a hard fought game, and we'll see what happens. But essentially, I'm on a wait and see mode. So I'm excited to see what happens, especially in the legislature.
Okay, I'll go next. Vijay, I had 3 words in my head, and you said wait and see. Kind of leads into my theme of my closing thoughts, which is more to come, because there's a lot still that's going to be happening and that has to play into effect. Obviously, with the rule coming down and the March day happening, there's still so much from challenges and from outside the state, and looking at the Black farmers here in the state, legislative times. There's still so many, it's early in the game, to Erik's point, there's so many different factors that are still going to play into it. So my thought is more to come. For people who are interested in finding out and working on ways to be more inclusive, definitely connect with Minorities for Medical Marijuana with myself and Erik and what we're doing here in the state. We would love to continue to collaborate. But yeah, more to come on what we have going on here in Florida. Because, you know, at the end of the day, Florida, we gotta make a show of it some type of way. It wouldn't be us if we did not.
All right. I guess, you know, my thoughts in Synopsis to start now and then spin it forward. I think this system failed the Black farmers once again, the way it was set up. I kind of think it was by design because there were conscious choices made here. You know, the lack of access to capital is going to be a problem for maintaining ownership as supposedly intended. And I think, you know, once the license is awarded, I think there's going to be litigation. And I think additional licenses are going to be dangled as settlement chips with respect to that litigation. And, you know, my prediction is that these licenses or license, once awarded, will probably be turned around and sold in short order, or at the very least not operated by the people that were intended to receive it and operate it.
Yeah, you know, and I kind of echo Sean in this. I do think that we missed the ball. Florida, we still have an opportunity to be more forward thinking when it comes to social equity. I think the legislative session gives us that opportunity if our legislator would be so bold. And, you know, Minorities for Medical Marijuana, we're certainly going to be there at the table, you know, doing what we can to try to move the needle on that front. But, you know, my hope is that every facet of our cannabis industry, from medical marijuana to the hemp industry to our adult use, once it eventually makes its way here, that we will have diversity at the top of our minds, that we will recognize that we have a true opportunity in this industry to create one of the most diverse industries that exist in this country. And that's my goal. That's something I'm going to be fighting for until I, you know, have no more breath to fight. But, you know, that is my hope. And I hope you all will join us in that. In fact, we do this across the country. And we're always looking, you know, for new partners in that fight. We do have a national program for public policy and the work that we do across the country and at the federal level. And we're always looking for partners on that. The work that we do, I think, is so vital to this industry. And, you know, we plan to be here, and we need your support to do that. So.
DJ, I think you're on mute.
I was in agreement with Erik saying absolutely, you know, across the country, and obviously here in our home state. Erik and I are both from Florida, and really hold that very near and dear to our hearts as far as the work that we do here. To his point, like, there's so many ways to partner with us, individuals, companies, even if you're looking to learn. Please definitely connect with us. If your vision and your intent is for the cannabis industry to be more diverse and to be more inclusive, that's definitely what we're about. And like I said, different programs like InProcure, which you can go to at inprocure.org to learn more about Black suppliers that we have here. And we even have a lookbook with Minorities for Medical Marijuana, where we have different brands that we've worked with within the organization, within our state directors and our leadership, those who have brands across the country. Definitely tap in with us on that if you're looking to partner and connect with Black and brown people who are doing really awesome work, honestly, within the cannabis space, and deserve the opportunity to be able to share that more. So we totally appreciate the opportunity. Vijay, Sean, Todd, I know you're back there probably with the kids. We really appreciate the opportunity to come and speak with you all tonight for this very, very important discussion and seeing what's going to happen looking forward in 2022. It's going to be an interesting year.
Yeah, shout out to Robert Friedman, man. He's been one of our biggest supporters from day one in this industry. Has always been. I consider him a friend. Him and Erik Stevens. So shout out to the whole C-Lab leadership, and we love the work that you guys are doing as well.
Awesome. So with that, guys, that kind of concludes our panel for tonight. Remember, we got our C-Lab annual conference coming up in early February. I believe we'll all be in attendance. So if you have any questions, either shoot us an email prior to, feel free to catch us up in Miami on February 4th and 5th. And with that, we got 109 days. So get your applications ready. You definitely want to partner with M4MM, Minorities for Medical Marijuana, as well as Fox Rothschild. So talk to you guys soon. See you guys.